We're here to talk about the JIB Resolution Procedure and what's been updated over 2024. I'm happy to introduce Jason Poulter as National Officer for Construction at United Union and Catherine Watt as Head of Employee Relations for the Electrical Contractors Association, the ECA. Both have agreed to join as the respective leads for their parties and who have really been the driving force behind updating this procedure over the last year or so. So while this will be quite a busy session and there is a lot to go through in terms of what the JIB offers in this space, how we support members and how ultimately as an industry we're working together to resolve a lot of these disputes, we thought it was a benefit to get the different perspectives on why this works as a model, what's been successful in the past, why the changes have come up, and Jason, Catherine will go through some of that. What you would need to do as an individual, what a company might need to think about in terms of response, and then how things like mediation, conciliation really work.
Lovely. Thank you, Andy, and good morning, everyone. I thought what I would do is just give you a bit of background on the resolution process, how we came to the point where it needed to be reviewed, what the history was, and its evolution to where we are now, which is our dispute process, which Andy will talk me through later on in the webinar. So, fostering good industrial relations was always key to the creation of the JIB. The 1950s and 1960s were characterised by widespread industrial action. And one of the driving forces to the creation of the JIB was to resolve that industrial action, to create agreed terms and conditions, and to establish a mechanism to resolve disputes within the industry. And as such, you know, from 1968, the JIB has always had a mechanism to resolve disputes, procedures in place for members and directly employed operatives to resolve issues within the industry, to the point where it received an exemption order for the dispute process, which gave it an equal footing to an employment tribunal or the old industrial relations tribunals. And the exemption order gave it a legal footing, the ability to hear claims as an employment tribunal would, and all industry disputes were channeled through that mechanism. So it had a really established means to resolve disputes, but because it sort of mirrored an employment tribunal, as employment tribunals developed, it became quite legalistic and bureaucratic. And I guess that was the point that we got to where we said, actually, this process is becoming too burdensome and it needs to be streamlined. It needs to be become effective and more accessible. And that was really the starting point for the review. And a working group was convened consisting of Unite and ECA, and we looked at the resolution process. Can you go to the next slide, please, Andy? Because I think one of the issues with the process, that because we were mirroring an employment tribunal, the evolution of employment tribunals impacted our dispute process. As you know, when an employment tribunal started, they were really looking at resolving disputes through the norms, industrial relation norms, but they've grown. They now resemble more of a court system, and as such, are costly and difficult to access, because I'm sure you're all aware that employment tribunals are overburdened. So I think the current stats are that it takes 49 weeks for a case to reach its first hearing. So in terms of accessibility, it's really a barrier to resolving a dispute. And, that clearly establishes the need for an industry process that would help resolve these issues quickly and efficiently. So that, together with this process that used to have an exemption order, the exemption order was revoked. These factors together brought us to the point that we needed to review this process, which hadn't been reviewed in over 40 years. So it had been added to, but not that wholesale review. And I guess one of the things that we wanted to establish at the outset was first principles. You know, it wasn't let's throw this process out that had been working efficiently and effectively. It was let's look at the principles of that process, establish them, and just make the process more accessible, less bureaucratic, and take some of the legalistic terms out, because we were no longer operating the process with that legal standing. It was an industry process. Next slide, please, Andy. So one of the first things that we agreed was that mediation should sit at the heart of the process, that and it was in that respect that we renamed it from the dispute process to the resolution process, to really force that through, that this was a process that used mediation, the voluntary process of mediation, to support the parties to resolve their issues collectively, not to take the issue off them and to put it through a more formal process, although that is available as part of the process, you know, a secondary option. We wanted it to remain an industry process, and by that we meant that it was a joint process with employers and Unite, and that would jointly act to resolve issues. And in that respect, the panel members are made up from both parties, and the experience that those parties bring to bear to resolve those issues is key. Obviously, we wanted it to be free at the point of entry for all members, so I mean, that's a huge benefit to members, because the cost of an employment tribunal, not only in terms of time, effort, but you know, the legal costs of getting support with claims, etc., is a huge benefit to both members and employers. This is one of the only industry processes that offers compensation as well to employee operatives. So in that respect, it's a more comprehensive procedure, and it's accessible from day one, which is quite a buzzword at the moment, isn't it? And a key to the, you know, the Labour Employment Rights Bill. They're talking about day one rights, and certainly the UK have had a variety of qualifying periods for unfair dismissal. But the JIB have always had accessibility from day one. So, you know, whilst, and I think that's sort of indicative and of the whole process, in terms of, whilst we have updated and renewed some aspects of it, the key principles have been retained, and that I think that demonstrates, it's demonstrated through that point. And of course, it's voluntary. It's voluntary for members, it's voluntary for employers. There's still the employment tribunal option, but we think that this process gives employers and employees access to a more efficient and easy to access process, given the context of the employment tribunal system and the backlogs that they're currently suffering with, and also the expertise that this process provides to employers and operatives. So with that, Andy, I'll hand back to you, and I think it's Jason next.
Thank you very much, Catherine. As you say, in looking at the landscape at the moment, kind of 49 weeks plus for getting through tribunal and kind of getting that day in court, so to speak, it's a huge burden on taxpayer, on the system, resources across the country. That I would say this, of course, I think we can deal with that better in industry, and ultimately with people that know more about the realities of work, particularly for electrical contracting. So yeah, great, and thank you for that. And so next, I'll hand over to Jason Poulter, as National Officer for Construction and Unite the Union, who again has been one of the key leading figures in updating this resolution procedure. So Jason, hand over to you. Please talk about some of the benefits for your members for mediation and conciliation.
Thanks, Andy. Thanks, Catherine. Morning, all. As Catherine says, we've done a lot of work through this, and we've worked on it for some time. And there were some principles that we were keen to retain, and it was the principle of sort of industry standard and industry support, and that is key to making this work. So when we look at the conciliation and mediation element of it, we know, we monitor this, it's proven and it works. The stats show us that the best results come when people start the process and enact with it for early conciliation. And if we don't get through there, mediation, 9 times out of 10 is where we resolve the majority of issues. It's an early intervention tool at conciliation stage. It is recommended, and one of the key things that we wanted to retain, as I say, was the access to that early conciliation at any stage. So it doesn't require a dispute to be formally raised. So that's really helpful to employers being able to pick up the phone and enact that, or the employees, the union officers. That is a support there that we would always recommend utilising. It's free and it's industry specialists. It's people who understand the industry, understand the unions, understand the ECA, and are willing to work together to resolve the issues right at that stage. When we move in towards the mediation piece, this is, where it doesn't usually go beyond that. It's a proactive step. And what we mean by that is both parties go into that mediation space understanding that they want to resolve the issue. They understand the issue more by this stage. The forms have gone through, and each party's had a conversation with their relative representatives, and they move into the mediation space in a proactive manner with a willingness to move towards each other. And that is key. It's less legalistic at that stage. It sets a scene that's a little bit more familiar, but it's still structured to move the parties towards each other to get those best outcomes. And the benefit of that, and we've always been keen to say it, is that there is no reputational damage to employers. It's not out in the papers. It's dealt with in-house. There are no costs. We've discussed the 49 weeks and the sort of challenges that brings, the length of that, and the cost around that. You can imagine it rolls on, and it is a constant thing. And that's 49 weeks to start a process. It's not to get to the end of it. But what's keen for the employees and the union and the employers and the representatives at the ECA is there's no long-lasting relationship fractures that can often be the case with tribunals, bringing in the lawyers, the very professional people, but dealing with it within industry at mediation space brings us out of that without a fractured relationship. There is no long-lasting damage to, as I say, reputations or those relationships on the ground that are key to keep a business and employees moving forward.
Thank you very much, Jason. Really appreciate your view perspective, as well as the hard work to update the procedure and make sure this is fit for practice. I think that certainly for me, one of the big benefits from this process has been that representation piece. What we've always seen in terms of better outcomes that come from individuals being represented by Unite and employers being represented by the ECA has always led to earlier intervention, better resolution, quicker times, and ultimately preserving that employment relationship. So really appreciate your views and perspectives on that one. So what we're going to come to now, and hopefully that's kind of set a bit of the scene in terms of why the procedure is there, why this was developed during originally in the 1960s, and as Catherine said, probably needed a little bit of an update. As all have said, it is a free, voluntary, and confidential service. The whole purpose of the JIB and the setup originally was to help resolve those industrial disputes. It is a form of alternative dispute resolution, and there is a history of successful intervention. So JIB's dealt with almost 3,500 claims since the inception of that process, and we always try to focus on positive early intervention rates of 90% plus, normally 95% plus, for success of things like mediation and conciliation. So that is promoted as the best option and the best outcome. But again, as Catherine and Jason have said, there is a structured process that can be utilised as well. So less formal, but still structured. And that is kind of the way in which the application forms need to be submitted. What is the claim? And then how does an employer respond to that claim? What the timescales should be, when do you expect to get involved? And if things can't be resolved at mediation, say, or early on by having a bit of an informal discussion, then what do those processes look like? And what does the independent review of that look like as well? So decisions are made by industry representatives, and I suppose emphasising the point that I made earlier, I think that's one of the reasons that this does work, is that you're going back to the principles of the old industrial tribunals, that these are businesses and employer representatives that know how things really work, know the real world, as well as having that detailed knowledge of the law and the JIB collective agreement, the national working rules in these areas. So we've already said the goal of this review process was to develop something that was simpler, that was streamlined, that was less formal, just because the processes are there to avoid the employment tribunal doesn't mean that I have to be a carbon copy of. And while we've looked at the number of stages involved and how forms are submitted and all of the kind of detail on this stuff as well, one of the aspects and why we're doing this today is that we need to improve awareness. We want this to be a process that is utilised. We want to ensure that member companies and their employees are supported and that they know this is an option and they know what their rights are in that scenario, and what we would see as the way in which that these disputes can be resolved, as I say, as quickly and as effectively as possible. So yes, no qualifying period. What's that mean? It's what we mentioned in terms of day one access rights. Again, has always been part of the resolution procedures back to the 1960s, and there's always been something that has been managed well. A lot of the concerns that we have seen in the news recently that people talk about with things like kind of day one rights is how do you manage things earlier on during a probation period, for example. Now, just because somebody might be kind of under at the moment 2 years service doesn't mean that there shouldn't be a process followed. But the process that you might follow for somebody that's been in for 6 months or 12 months would be probably very different to somebody that had been in with a company for 20 years. So there's a reasonableness element to that. And I think that that's important. When we talk about mediation and conciliation, mediation may be a little bit more formal, more structured. Conciliation tends to be earlier on in a process where one of the JIB team would be contacting the individual, contacting the company, and trying to see if they could proactively resolve things at the earliest stage. Certainly, over the last 6 or 7 years, conciliation has been very effective. And some of that is just due to simple errors of understanding on one side or the other. But that tends to be quite an effective tool. So again, we do say that is available at any stage of the process. Individuals, companies can always reach out and ask for JIB support, even if things haven't got to the point of submitting a formal application, for example. So the types of claims fall into 2 categories. It's those related to dismissal, which is covered under National Working Rule 19, and grievances. So that could be things like underpayment of wages. It could be disputes over how a particular national working rule is implemented, say for travel costs, maybe something like that. There are certain claims, though, that are outside of remit. And again, this is quite explicit under the procedures, and has always been the case. It cannot be used to hear claims that fall under the Equality Act. So these are discrimination claims, things like harassment, victimisation, TUPE, areas where the law is quite complex, to be polite, and other areas where there might be a conflict. So claims of blacklisting, whistleblowing, trade union membership, given that stages in this process could be hearings from or panels made up of employer and union representatives. Obviously can't be making decisions on areas where that might directly relate to trade union membership, for example. So in that circumstance, if individuals have a claim, the employment tribunal may be the correct option. But with certainly kind of the normal unfair dismissal claims around conduct, capability, redundancy, things like that, JIB procedures is what we would recommend. So updated in 2024 is whole new guidance for the procedures on how to access what you should expect at each stage of that process. Simpler, easier, less complex language, to be honest, as well. So that's now contained within the JIB handbook. That's section 3. So you can download that from the JIB website for free, and it's in the printed versions as well, of course. And in that way, more easily accessible to people. We've updated some of the forms in terms of better step-by-step processes for what the expectations are for individuals, and particularly around things like collective grievances. We've always tried to be pragmatic, and if multiple people are raising the same issue with one company, then we'll deal with it at one time, of course. But there was never a formal process set out for dealing with these types of collective grievances. So there is now. There's more focus certainly on getting things resolved early. So we talk about this point on mediation, conciliation. Again, any point in time, people can come to the JIB for that support. There's also been some changes in terms of timescales. Now, for anybody that might know the processes through the employment tribunal system, you need to go to ACAS to obtain an early conciliation certificate. This is normally a process that requires you to go to ACAS to start that early conciliation process within 3 months of whatever the event was, whatever the issue that gave rise to the claim. That then starts a period for potential conciliation that ACAS will arrange, and that can be 4 weeks or extended to 6 weeks if there's a likelihood of resolving that. After that period of 6 weeks, there's at least another month in which people will then have the opportunity to submit their ET1 form, which is form to submit claim to tribunal. So what that means is you could get to a stage where you're 5.5 months down the line from an issue before you've even submitted the form. Do you then have to take into account the employer's time for response, and then what we said about hearing times, the resources on tribunal court systems? It can be a very lengthy process, and what that tends to mean in our view is that people become a little bit entrenched, and they're less likely to then try to resolve things amicably down the line. So if you can avoid all of that, I think it's a benefit to everybody. It also means that for us that we don't have those complicated timescales anymore. Claims need to be submitted within 3 months. There will be exceptional circumstances, don't get me wrong, but that again does need to be exceptional. Otherwise, 3 months is the time limit for the process. And this isn't there to be 2 bites of the cherry, so to speak. The people should be using one procedure or another. So if they want to use the JIB procedure, then absolutely fine, but it doesn't mean using the tribunal process as well. So again, being quite clear that if people are pursuing cases through the tribunal, that's absolutely their choice. That's a statutory right. But then they won't be eligible to use the JIB's procedures. We've also looked at the issue of compensation. Again, calculating compensation and loss under some of these claims when things get past a formal hearing is quite complex. And there were lots of different claims that could be taken into account for a tribunal, including things like future loss, so beyond the date of the hearing, and as well as penalties against individuals or employers for behaviour during the process, and lots of other things to be taken into account. We've tried to simplify all of that. So there's no penalties, there's no complex financial calculations. It is losses up to the date of the hearing. And then because this is a industry created process, the only organisations that are able to represent are ECA on behalf of employers and Unite the Union on behalf of employees. So how does an individual access the process? Well, it's an application form that needs to be completed, and ultimately they're asked for personal details, contact information basically, and details of the claim, any evidence. So any letters, documentation, emails, payslips, whatever it may be that supports the claim. That's then compiled and sent to the company for a response. They have what's called a respondent's form, and again that says do they accept the claim or reject it, and then what's their response, and if they've got any supporting documentation that needs to be reviewed. After that point, we'll look to set up a mediation meeting to try and get people in a room to go through, have that discussion, hear the different perspectives on what's happened, why we are now where at the stage that we are, and resolve it if we can. If that's not possible, then there's a SIF stage to review the likelihood of success of the claims, and a review. If that's approved, then it can proceed to a dispute hearing. Now, I mentioned timeline late applications. So 3 months, again, we'll reiterate, the claim needs to be submitted by. Ultimately, people need to be aware of those time limits. There's kind of no excuse for not knowing, for a lack of information. So it is exceptional circumstances, medical issues that have come up in the past being an example of, in which they may be allowed. So otherwise, 3 months being the key time frame there. So collective grievances, this is a bit of a change for this year, and something that even the court processes, ACAS don't always deal with particularly well, because it is quite a difficult and complex area. With collective grievances, there is now a process for assigning a lead operative. So there should be a named individual that can be contacted and be effectively the representative of the speaker on behalf of colleagues. The forms, though, can be completed by a Unite the Union official, a regional officer, for example, and that will need to set out all the individuals that are involved, ECS card number so that everyone can be contacted. But there's no need to sign physical documents as there was previously. What we do need to ensure, though, is everybody's communicated with. Each individual's claim, they will need to calculate their losses. They will need to set out what the information is and relevant. So they all need to be involved as part of the process, but it's much more streamlined in that way, and not as segmented as it was previously. There's still a SIF stage, as I mentioned, and this is the same with court processes, what they might kind of call frivolous and vexatious claims. You say, is there a reasonable chance of success? Is this a claim that should proceed to a hearing? Now, most of the time we don't get to this stage because things have already been resolved one way or the other before this, but if so, all claims get an independent review on whether they should proceed or not. If those are rejected at that point in time, there is an appeals process for those people that have more than 2 years service, and either way, written confirmation as to the reasoning behind that decision is communicated to all at each stage. So a resolution hearing, so that panel. So if claim is submitted, the employer submits their response, and it's not something that could be resolved by mediation. Ideally, 4 to 6 weeks after the company response, we'll be setting up a panel. That's one representative on behalf of the ECA, one representative on behalf of Unite the Union, to make a decision on behalf of industry, independent of their respective employers or representative bodies. They should be making a decision on the evidence provided. JIB staff do not make those decisions. We are only there to inform on the application of the law or the JIB agreement, the national working rules, and those are always held in private. So those matters are confidential, and in that way we try to best evaluate what the claim is and how to manage that. So one of the representatives will chair that meeting, will talk through with both sides ahead of time in terms of what the process is, if there's any witnesses that need to be called or attend, what the complaint is, if any of them have already been resolved. Sometimes you get that, multiple complaints, multiple claims for the same person. Some elements might have already been dealt with. And then what's the company response? Basically giving the opportunity for both sides to have their say, to take their time to talk through what their view and perspective is on whatever this issue is. Say it's a dismissal, for example, of why that occurred, what the process looked like, why it was fair or unfair, and then ask questions of both sides. So there's an opportunity for the panel to ask questions, there's an opportunity for each side to ask questions, and then ultimately at the end, give a summary of their account. The chair will go through process for conclusion and then ultimately make a decision. So they go away to deliberate, they will come back and confirm same day what the decision is and any outcomes. So for dismissal claim, that would be either that there's no finding of unfair dismissal, it was fair process in the circumstances, or it was unfair, and then an order for re-engagement, reinstatement, or compensation. I'll come to what those are in a little bit. For grievance claim, say an underpayment of wages claim. Either there is no claim to answer and find in favour of the company, or find in favour of the individual, and there's compensation awarded. And again, that should be calculated on the day as well. So the decision is made on the information that is provided by both sides. It will need to refer to the JIB agreement. It will need to refer to the law. And as I say, if compensation is to be awarded, the panel have to calculate that. They will need to give that calculation on the day to the parties, to the individual and to the employer, and a summary decision will be sent within 3 working days to both sides, with a full written decision normally within 7 working days. That will contain the right to appeal, because both sides may appeal. 2 grounds for that. Either there was an error in the application of the law or the application of the national working rules, or the decision was not one which could have been reasonably reached based on the evidence available. So full written decision within 7 working days. After that, if there is to be an appeal, that needs to be received within 5 working days. There is no appeal process, though, if the matter is being pursued through tribunal. So again, this need to avoid a twin track approach. Either people are using the JIB's procedures or they're using the tribunal procedures. So not that this has ever come up, but particularly with some of the outcomes you might see from a dismissal claim. I mentioned re-engagement and reinstatement. Now, reinstatement is if a person is found to have been dismissed, it was unfair, and the order from the panel might be that they ultimately get their job back without any loss of earnings in the interim period. But that's not always possible. So re-engagement would be in order to basically go back into the company, but maybe in a different role or a different position. Not back into something like for like that they were before, but neither of those are always possible, particularly if it was a redundancy scenario. For example, the role may no longer exist, so you can't order reinstatement or re-engagement in those types of circumstances, and then the outcome is compensation. If there is a failure to comply with reinstatement re-engagement orders, ultimately what would happen in that circumstance, JIB would be notified, the panel will be reconvened, and then there is what's called an additional award, which is up to 52 weeks pay. That is the same calculation as would apply through the employment tribunal. As I say, in kind of 3,000 plus claims, I'm not aware that has ever been the case, but it's just worth pointing out because that's still part of the process. As I mentioned earlier, the resolution procedure guidance is all on the JIB website, but most of that is also available within the handbook as well. So section 3 of the handbook, download that from the JIB website, and we'll circulate round the links to that page with this recording and the outcomes as well. Thank you to those people that have been putting in questions during the process. I'll go through and try to answer as many of those as possible and direct them to either myself, Catherine, or Jason, if you're happy to answer some questions in terms of who may be kind of most appropriate. So I'm going to start with the easy ones, and I'll leave the harder ones for Catherine and Jason, if that's okay. So somebody asked in terms of process, what's the time process on this? So we aim to resolve any claims within 6 weeks of getting the employer response. So that should be through to a panel being set up as well. Maybe not necessarily the appeal stage, but as I say, 99% of claims are resolved within the period up until the hearing date. So that is the intention. Most are quicker than that. It does depend on evidence available. It depends on if it gets to hearing stage, on people available, dates, etc., venues. But that's what we aim for, 6 weeks. So should be a far quicker, more straightforward process than tribunal certainly. So somebody's asked in terms of if what happens if an employer refuses to participate. So Catherine, would you be okay picking this one up?
Absolutely, yeah, no problems. I mean, I think that's the nature of a voluntary process. Yeah, the nature of the process is that it's voluntary, so it does require both parties to agree to take forward. I mean, with mediation and conciliation, that is the fundamental basis of it being effective. I'm going to be really annoying now and say that I've never known an employer refuse to participate. And I guess that's because there's mutual interest in resolving that dispute. The employer wants to resolve it. They've an employee in the workplace and this is continuing to cause issues, or the employer's left and it would have helped them avoid a tribunal. So there's interest for both parties to resolve the dispute. So I've not known an employer refuse. So we've never actually had to deal with that circumstance, but the process is voluntary. And you've got to remember that JIB members companies are responsible, sign up to the terms and conditions and want this process. They value the process as much as operatives. So that would be my answer to that one.
Yeah, absolutely. And that's been my experience as well. When you have that conversation, you explain the purpose, benefits. Yes, it's voluntary, but it's been industry recognised for decades, and I think that's all to certainly the benefits of. So there was a question as well in types of employment claims excluded. Again, hopefully you answered that during the discussion of the process in terms of Equality Act claims, in terms of discrimination, victimisation, trade union membership, blacklisting, whistleblowing claims, etc. If there are any other examples that you were thinking of in particular, then feel free to send those through. But hopefully that has answered your question. Jason, wanted to ask from yourself, I suppose, about what the process would be for individual representation, how somebody should reach out to Unite if they are a member, and then what are potentially the benefits of being represented during the process from your perspective.
Thanks, Andy. So a member of Unite the Union, when they get into difficulty or they think there's something not correct, they should reach out to the union at the earliest opportunity. So you can contact your regional office. If you don't know who your officer is, our staff at Unite the Union will take consideration of who you work for, where you're working, and they will assign you to the most relevant officer. We've done a lot of training with the officers on this procedure, and they will be able to support you straight away. And if you've got to raise that grievance, or if you've got to raise it at the earliest stage with your most immediate line manager, which is what we encourage people to do, what people should be doing, the union will support you all the way through that. If we don't get to a resolution at grievance or even appeal stage, as said, we will support your early conciliation. We would accompany you, take you or that issue, your workmates, fellow employees. We would represent you in that mediation process. And again, on the 5% of cases that can be resolved there, we will support you right through that process going into the panel hearing. So we'll do the paperwork for you, support you, and make sure that we represent you to our best ability.
Thank you very much for that. And I suppose same question to yourself, Catherine. How can companies get in touch if they have an issue, a potential issue, or a claim submitted to reach out for support and advice?
They can do just that, Andy. Yeah, that's absolutely what they can do. They can reach out for support and guidance, and that's exactly what we do. We support employers go through that process with paperwork. Very much the sort of yin to the yang of the Unite. We do what Unite do, but for employers, and of experience of going through the process and supporting employers successfully. So yeah, get in touch, and happy to answer any questions and support any issues that arise.
Thank you very much. We've got time for one more question. Question coming from Dave, asked about timelines, and particularly where claims might go over that 3-month period, or internal processes haven't resolved. So we always talk about recommending that people go through the internal processes first, internal appeals or grievance procedures. But if that's not possible, then you should get the claim submitted to protect yourself before the end of that 3-month period. So what would happen in that scenario is effectively we would pause that, would notify the employer that that's been received, but we would pause while you attempt to resolve the internal process. This isn't a duplication or meant to be a replication for a company's own disciplinary and grievance processes. They're still there, then that should be followed first. So yes, if there is an issue with potential time limits, we'd say submit the claim, and then that can be picked up at the end of that internal process, which hopefully again resolves the issue, and then the claim can be withdrawn. The other question connected to that was about outcomes. So there's a question around if an individual asks for or talking about reinstatement. What if the individual doesn't want to go back? That's completely their choice. It always has to be a decision based on what the individual is requesting, what they are asking for. So if they're not asking for reinstatement or re-engagement to be reviewed, then it won't be reviewed. So there is absolutely an element of choice there. And how is compensation then calculated? Again, I would say speak to your relevant representatives. They can assist in that process, but it is focused on things like loss of earnings up until the date of the hearing. So that should be a relatively straightforward process to go back through and look at the contract, look at the grade, look at the rate applicable to the individual, because it's covered under collective agreement. But again, representatives can assist with some of that, because it might get complex at times. Last one, because I realise we are very short on time, was just about sharing best practice or decisions reached. Now, both Jason and Catherine have already talked about the confidential nature of the procedure and the benefit that comes from doing that. However, you're absolutely right that there might be circumstantial decisions reached that need to be communicated out, because perhaps there's a misunderstanding or some lessons learned, or as has happened in the past, cases have led to some of the rules being updated where there is a lack of clarity. What happens in that scenario is, through one of the JIB's committees, Employee Relations Committee, they will review the outcomes if there is potential precedent to communicate that out. So that's done without needing to know the names of the individuals or the companies that are involved. But in that way, they take a regular review, normally every 3 to 4 months, in terms of cases that are coming through, issues that have been dealt with, and then can address that, either communicate out to wider industry, and we will manage that, or, as I say, it might be a small working party or part of perhaps next negotiation process to look at updating the rules. So in that sense, there's an oversight process as well for that. Apologies, we're running kind of slightly over time, so I have to end it there. But what we will do, because I know there's a few more questions that were coming in as I was talking there, we'll make sure that we get some answers out to people as well. And then as we circulate round this session with the relevant information and the video, we can pick up on some of the questions that have been asked there as well, and set that out so people have got a bit of clarity on those areas. So lastly, just wanted to say thank you again for attending today. Please do get in touch with the JIB, with ECA, or with Unite if you've got any questions or need any assistance in these areas. We're happy to help. And thank you to Catherine and Jason for your time this morning on helping to run through that. And I think this is a fantastic piece of work that needs to be recognised, and we need to promote a bit more awareness of. So really do appreciate you taking the time this morning to help on that.